So let me share my screen also with you. So I hope my screen is visible. Is it visible?
Yeah, visual, sir.
Okay, okay. So let me tell you a story. Actually, suppose you are a home buyer. Okay? You are a home buyer, and you know that as a home buyer, you have got some alternative remedy also. That you can approach RERA. You can approach Consumer Forum also. So now, suppose you approached RERA and you got a decree under RERA. And now, because this company is into CIRP, so you file your claim with the RP also. And RP gave favorable treatment to the people who did not approach RERA, and the RP gave less favorable treatment to those who approached RERA. So, what is your view? Is RP correct in his treatment, or he should treat both of them on the same ground? So, in this case, Supreme Court held that I hope you have got this PPT with you in the group. Have you got this PPT? Yes, please.
One PPT there, 41 Supreme Court case, total
Okay.
41.
Okay. I hope I have already shared this PPT. Let me share it again also. You are in May group or April group?
May Group.
May group, okay. Let me share it. I've shared it now. So, Supreme Court said that RERA is an alternative remedy even if a home buyer has approached RERA and has got a decree, but the treatment here should be the same because even if there is a decree, there is a concept of moratorium. In IBC, as you know, you might know that there is a concept of moratorium where all the proceedings are stayed. So naturally, even if a decree is issued, it cannot be executed during CIRP period. So Supreme Court said that there should not be any distinction between home buyers whether they have obtained any decree or not. So this is, they can put you some question also on this because even RERA is in our syllabus. Let us take another case. This Greater Noida Authority, they filed their claim as financial creditor. And we have studied yesterday that these landowners, these land authorities, they are treated as operational creditors. Now the question is, suppose a person, this Greater Noida Development Authority, they file a claim as a financial creditor. Now RP tells them that you file a different form. You file because you are an operational creditor, so you fill up that form. Now in this case, Greater Noida Authority, they did not fill up the form. And RP proceeded as if Greater Noida Authority has not filed any claim. So in resolution plan, they ignored the claim of Greater Noida Industrial Development Authority, stating that Greater Noida Industrial Development Authority did not file any claim. But the Supreme Court said RP should have considered the claim and resolution plan was remanded back to the COC. So the point here is, if we see the regulations, so the regulation says a person claiming to be a financial creditor or a person claiming to be an operational creditor will fill up this particular form. So they say what the claimant has done, he has simply claimed that he is financial creditor or an operational creditor. Now it is up to the resolution professional or the IRP to find out that whether he is a financial creditor or an operational creditor. Okay? This is given in the regulations. If we see the regulations, CIRP regulations, if we see, In CIRP regulations, I'll tell you the regulation number. So in CIRP, it says a person claiming to be a financial creditor or a person claiming to be. Yes. So regulation number 8. If you see claim by financial creditors. Regulation number 7. Claims by operational creditor. A person claiming to be an operational creditor. So the wording here is important. Let me take you to that. Just a minute. Now in this PPT, this is the regulation number. I hope it is visible on your screen now. Is it visible? A person claiming to be an operational creditor. Is it visible?
Visible, sir.
Yes. So Supreme Court, they put emphasis on this wording. A person claim. So they say whether he is an operational creditor or a financial creditor, he may not know. He is simply claiming. Now it is up to you. It is up to the IRP or RP to judge whether he is really an operational creditor. Similarly, in financial creditor also, you will find a person claiming to be a financial creditor. So Supreme Court, they gave reference to this regulation and they said that it is up to the IRP or RP to see that whether that person is a financial creditor or operational creditor. And he should consider the claim accordingly. He cannot ignore the claim. Because now, as of now, what the IBBI is doing, IBBI is framing practical situations. Those practical situations may be based on these case laws also, or they are based on case studies also. So they might frame a case study like this, that this Greater Noida Industrial Development Authority, they have leased a land. Right? So they have given a land on lease to a particular party. Now, once they give the land on lease, whether it is a financial debt or an operational debt, this is the first thing. Suppose Greater Noida Industrial Development Authority, they have given a land on lease to a particular company. My question is whether it is a financial debt or an operational debt. It is an operational debt. Land authorities are considered to be operational creditors. Next point is on liquidation. In liquidation, as you might have noticed, that there is a bidding process, there is an auction process. Now the point is, suppose the liquidator has got the highest bid. Okay? Liquidator, the bidding process was completed and there was a highest bidder emerged. But there is a provision in the regulations that despite being the highest bidder, the bid can be rejected by the liquidator. So in this case, highest bidder appeared this Eva Agro Private Limited. I hope the screen is visible. Is it visible now? Eva Agro Foods.
Yes.
Yes. So what you can do is, if you do control enter, then you will find the case law also. Just a minute. So in this case, if you do this control plus enter, you will go to that case law. Right? So I have given proper linking to this. First of all, I have given the summary and then in detail, case law in detail. So here we were discussing this case law where a successful bidder emerges and then the liquidator rejects that bid. So the point here is whether the liquidator is right in his action. This is the case. So highest bidder, Eva Agro Foods, they emerged as the highest bidder, but still their bid was rejected. But Apex Court declared him successful bidder. Because actually the liquidator rejected the bid on the ground that there is an expectation of a higher bid. Right? So Apex Court said that expectation of obtaining a higher price in a subsequent auction did not constitute a sufficient reason for cancellation. So because Supreme Court was of the view that there is no limit to higher expectation. Okay, tomorrow you may get a bid for 2 crores and you say that we are expecting 4. If you get a bid for 4, you may say we are expecting 6. So there is no limit actually. So they said normally there should be other reasons. So simply expectation, if your expectations are not met, it is not a sufficient reason for cancellation of the auction bid. This was the case. In the matter of Hari Babu Thota, what is the case? The point here is that yesterday also we discussed that this 29A, section 29A talks of ineligibility. So section 29A talks of various scenarios in which a person may be ineligible. So there is one clause 29AC which says that if the person who is trying to become the resolution applicant, if he is having an NPA account or he is controlling a company which is having an NPA account, then and a period of 1 year has elapsed from the date of declaration of this account as NPA and the CIRP commencement date. So then he is not eligible. But this ineligibility has to be seen as on the date of submission. Okay. So cutoff date for determining whether resolution applicant is disqualified would be the date of submission of the resolution plan and not date of commencement of CIRP. Another point is that also we discussed yesterday that in respect of MSME, there is a certain relaxation in terms of the eligibility of the resolution applicant. One is regarding this 29AC, which talks of NPA accounts being held either by the resolution applicant or by persons associated with him or connected with him. So they say this clause will not apply to an MSME. Now the question here is, suppose there is a resolution applicant. Now this resolution applicant has registered himself as MSME if after the CIRP date. So whether we can say that since he got himself registered after the CIRP date, so it was an afterthought. So Supreme Court said that our resolution applicant could register himself as MSME even after the CIRP date. As long as he is an MSME as on the date of the submission of the resolution plan, then it is fine. Because this eligibility or ineligibility has to be seen at the time of submission of the resolution plan. I hope this point is also clear. Yes, please. Pradeep ji, you are there?
Yes, sir, I am there. Yeah.
Okay. So this point is clear to you?
Yeah. Yes, sir.
Okay. So now next point. Next point is sometimes what happens is, suppose a person submits a resolution plan. So then he is required to give a bank guarantee. Why this bank guarantee? To ensure successful implementation of the resolution plan. Because what is a resolution plan? A resolution plan is nothing but a set of promises that, okay, I am going to dig this company out of this insolvency crisis and I will run it as a going concern. So he makes a set of promises which are to be fulfilled during the implementation phase. Now in this case, he had given a performance bank guarantee. So normally section 30, if you see, so section 30 talks that, okay, you have to give the performance bank guarantee so that it can be assured to the corporate debtor that you will be implementing the resolution plan. That means you will be fulfilling the promises which you have made while submitting the resolution plan. Now suppose you have submitted a performance bank guarantee and you have said that, okay, I will be infusing 350 crores. Now in this case, what the resolution applicant is saying, the resolution applicant is saying that I have already given you performance bank guarantee of 150 crores. Now you adjust 150 out of this 350, which I promised to infuse. So Supreme Court said no, nothing to it. Performance guarantee is to ensure successful implementation. So we cannot adjust this 150 which you gave as a performance bank guarantee against the 350 crores you promised to infuse. So adjustment of performance bank guarantee of 150 crore against the first tranche payment of 350 crores is not permitted due to failure of the successful resolution applicant to infuse funds and non-payment of CIRP costs such as airport dues. Apex court ordered liquidation. So this is the case of this Jet Airways. So in Jet Airways, this person was the successful resolution applicant, consortium of Murari Lal Jalan and Florian Fristek. But they said that, okay, you adjust our guarantees. There were some payment issues and they even did not clear the airport dues. So Supreme Court said that since they have failed to implement, so there is no choice except liquidation. I hope this case law is also clear. Yes, Pradeep ji.
Yes, sir.
है ना? Have you gone through these case laws? So what I've given is I've given the linking also. Suppose you control plus की
Yeah.
click है ना?
Yes.
So you will find the details here. है ना? ठीक. चलिए. ये भी हो गया. So I'm trying to make it very simple so that it is very easily understandable. Now High Court case laws. In High Court, what was the case? Section 7(3)(a). Section 7(3)(a). Let us see Section 7(3)(a). Okay. So what it says, it allows the FCs to provide either a record of. Can you read from Section 7? Pradeep ji, can you read Section 7(3)(a)? Just a minute, and then we'll discuss.
Yes, sir.
Let me open it also.
Yeah, so the financial creditor shall, along with the application, furnish record of.
7(3)(a). Yes, yes.
Yeah.
Hmm.
So the financial creditor shall, along with the application, furnish record of default recorded with information utility or such other record or evidence of default as may be prescribed.
So the point is, they have used the word or here. So that means it is alternative. But the Supreme Court said that, okay, this furnishing of record of the default recorded with information utility is a must. So this NCLT, they interpreted it this way. And there was an appeal to the High Court by way of a writ petition. So High Court said that Section 7(3)(a), it allows the financial creditors to provide either a record of default, as we have just now read from the section. So you have to provide either a record of default from an information utility or other evidence of default, or indicates that submitting a record from an IU is not the sole method. So it is not the only method. You can prove default in other ways also. Suppose you have not recorded your debt or default with the information utility, then what you will do? So NCLT's attempt to apply the directive retrospectively to pending cases. So Supreme Court here said that this NCLT said that, okay, this has to be applied retrospective, that even in those cases where record of this default has not been provided, even those applications are to be rejected. But High Court said that subordinate legislation, it cannot have retrospective effect unless explicitly authorized by the parent statute. So Section 7(3), so it was, so this High Court, they provided relief. So they said, then they rightly interpreted it because they say it is alternative mode. It is or, not and. This was the question. Next is, there is a Section 32(a). If we read Section 32(a) of the IBC, what it says that once a resolution plan is approved, then the corporate debtor as well as the new promoters, they get immunity from prosecution because they had nothing to do with the previous promoters. Whatever fraud has been done, that has been done by the previous parties. So the question here comes, suppose PMLA proceedings are going on and ED has attached certain assets, then what will happen in that situation? So it says Section 32A, which provides immunity to the corporate debtor from prosecution for prior offences once a resolution plan is approved, does not extend to attachments made by the ED under the PMLA, which are criminal proceeds. So, because if you read 32A, in 32A also, there is a particular, Pradeep ji, you read from section 32A, please open section 32 and I'll tell you where from you can read it. 32A says particularly that suppose 32A1B, if we read a person with regard to whom the relevant investigating authority, so the relevant investigating authority here is the PMLA, on the basis of material in the possession, a reason to believe that he had abetted or conspired for the commission of the offence and has submitted or filed a report or a complaint to the relevant statutory authority or court. So if a complaint has been filed, if a report has been filed to the relevant statutory authority, then this immunity is not available. So they say this PMLA, it refers to the proceeds of crime, and this even if the resolution plan is approved, so it does not extend to the attachments made by the ED under this Prevention of Money Laundering Act. So for that, you have to approach the adjudicating authority. Adjudicating authority for PMLA is different. So they said that you don't have to approach NCLT for this purpose. If you want any relief, you have to approach the PMLA, authority under PMLA. Next case is on CA V. Venkata Sivakumar. This because in IBC there is a concept of authorization for assignment. Now, what is this concept of authorization for assignment? Suppose you are a chartered accountant, you are having a certificate of practice. As a doctor also is having a certificate of practice. Similarly, a lawyer. So the point here is this there is a regulation 7A which mandates the criteria or the procedure for obtaining an AFA. So this was challenged. This regulation 7A which mandates that an AFA should be obtained, and bylaws 12A, they also contain the criteria and procedure for obtaining an AFA. So this was challenged by CAB Venkata Sivakumar, who was an insolvency professional also. But the High Court said that it is valid. These regulations cannot be challenged. So they are in order. This was the point actually. Next case is also on similar lines. So he said that regulation 7.2 CA and regulation 13.2 CA mandating payment of a fees, because there is a clause regarding payment of fees also calculated at 0.25% of the professional fees earned in the preceding financial year by the IP, and IPE was challenged. So in this case, this CA Venkata Sivakumar, who was an insolvency professional also, he challenged that why this board is charging, why this IBBI is charging fees calculated at 0.25% of the professional fees earned. Because if you are a professional, if you are an insolvency professional, you have whatever fees you have earned during the year, you have to pay a fees which is calculable at the rate of 0.25% of the professional fees earned. So this was also challenged. This point was also challenged. So Pradeep ji, can you read this regulation 7.2 CA? Now this IP regulations, insolvency professional regulations.
Yeah, okay. Insolvency professional regulation. Regulation 7, sir.
7A.
7A. You will find it in insolvency professionals regulations. Let me read it for you. An insolvency professional shall not accept or undertake an assignment after 31st December 2019 unless it holds a valid authorization for assignment on the date of such acceptance or commencement of such assignment, as the case may be, provided that provisions of this regulation shall not apply to an assignment
which an insolvency professional is undertaking as of, because this amendment came in 2019. So they say it will not apply to the existing assignment. This is regulation number 7A. And we can read bylaw 12A also. So this bylaws 12. So bylaws you will find in insolvency professional agencies regulations. So if we see the insolvency professional agencies regulations, so you will find the bylaw number 12. So there are model bylaws, and in model bylaws you will find the point number 12A. And what is this 12A? It also outlines the criteria basically. So this was challenged, and High Court did not find any fault with this criteria. Next point is on this Tata Steel BSN Limited, because Bhushan Steel was taken over by Tata's and a resolution plan was approved. So in this case, what happened is, before the resolution plan was approved, the RP filed an avoidance application. If you see section number 26 of CIRP, what section? Because there are these avoidance applications are taken up simultaneously, parallelly. One is the CIRP related procedure, application for initiating CIRP. Second is application for avoidance transactions. So these can go on. And if we read section 26, so section 26 says that these CIRP applications can go on even if the CIRP process is completed. So they are to be taken up separately by the adjudicating authority. So this is what is clearly written in section number 26. Applications for avoidance of transactions not to affect proceedings. So the point here is, suppose an application has been filed and a resolution plan has been approved. Right? So he filed an avoidance application against Venus Recruiters for suspected preferential transactions. After the plan approval, NCLT continued proceedings on the avoidance applications. Venus Recruiter challenged this before the High Court. Okay. So the point here is whether he can challenge these proceedings, and who is the person who will take up, who will follow these proceedings with the adjudicating authority. Just a minute. The point, this is the point. So Supreme Court said, this High Court said that this Venus Recruiter, he raised a plea that RP becomes functus officio and such applications cannot continue post CIRP. But the High Court said that he is well within his power to follow up with these applications. The court set aside the earlier decision of the single judge that avoidance applications become void after CIRP. Single judge gave this judgment that avoidance applications become void once a resolution plan is passed, but it was set aside by the decision of a larger bench, and it directed the NCLT to proceed with the hearing of the avoidance applications. So it was held in this case that PUFE transactions, the RP can pursue the PUFE transactions even post CIRP scenario. This is the case actually. Next case again by this V. Venkata Sivakumar. So in this case, disciplinary proceedings were initiated for allegedly sharing confidential liquidation information, because there is certain type of information which you cannot share with the stakeholders. Suppose you are a resolution professional and you are required to get the valuation done. So the point here is whether you can share that liquidation value with the resolution applicant. The point is no. The answer is no. So disciplinary proceedings were initiated against Mr. Venkata Sivakumar for allegedly sharing confidential information. Okay? And the point here is that he raised certain questions. He said that once a disciplinary proceeding is initiated, then the AFA stands automatically suspended. So this V. Venkata Sivakumar, he raised a plea that as soon as disciplinary proceedings are started, then there is an automatic suspension of AFA. So the point here is whether this amounts to punishment. So High Court said that it is not a punishment. It is a procedure, it is a regulation which is done so that the person against whom disciplinary proceedings are going on, he does not handle any new assignments. Another point here is whether he can handle the existing assignments. The answer is yes. He can continue with the existing assignments, but he has to inform the COC that disciplinary proceedings are going on against him. And COC, if they so desire, they can replace him with 66% majority at any stage. Another point that was challenged by V. Venkata Sivakumar, that there is a process of dual control by the IBBI and IPA. Because as we saw yesterday, IPA is the monitoring agency and IBBI is the regulator. So both are monitoring and regulating the conduct of insolvency professionals. So this Venkata Sivakumar challenged this point, that why this dual control by IBBI and IPA. But High Court said that it is not unconstitutional, and the concept of constructive res judicata was also applied for challenge to regulation number 7A, because this CA Venkata Sivakumar, he had challenged this regulation 7A earlier also. So this constructive res judicata was applied. So constructive res judicata, what is this concept? This concept is that if a matter is already being pursued before an appropriate court, then it will not be taken up again for consideration. So this is the concept of res judicata. And if a matter has already been decided, then also if another application comes up on the same ground by the same person, then it will not be taken up. So this is the concept of res judicata, which was applied in this case. Okay. Next case is by Shiv Charan versus adjudicating authority under PMLA. Now, this Shiv Charan, he was the successful resolution applicant. And a case under PMLA was going on, and ED attached the assets of the CD, and adjudicating authority under PMLA confirmed the attachment prior to the CIRP commencement date. Another important thing we have to keep in mind is what is the date of attachment. Normally, if the date of attachment is before the CIRP commencement date, then that is not put to challenge, and those properties are not handed over normally. So in this case, ED had attached the assets of the CD, and adjudicating authority under PMLA confirmed the attachment prior to the CIRP commencement date. So Bombay High Court released the ordered release of the attached assets in view of section 238. So this was an aberration, and High Court said that this 238 will apply in this case. The concept of this non-obstante clause, this IBC will override the other provisions. So here this High Court ordered the release of attached assets. Next case is of Go Air. So Go Air, as you know, it was an airline, and they had got aircrafts on lease from the appellant. So lease was terminated prior to the CIRP because there were some payment issues by the Go Air. So this lease deed was terminated. Now this Accipitar Investments Aircraft 2 Limited, so they were the lessors. So they had leased the aircraft to Go Air. So the appellant, they applied for cancellation of the lease to DGCA. So DGCA, they refused to process the deregistration. So it was held by the High Court that DGCA's refusal to process deregistration was illegal. ठीक है. Rule 30, sub-rule 7, if we say of the aircraft rules, it outlines the process for cancelling the registration of an aircraft registered in India when it is subjected to the Cape Town Convention or Cape Town Protocol. Specifically, the central government will cancel the registration if an application is received from the IDERA holder, International Deregistration and Expert Registry, before the lease expires, along with supporting documents. Okay? So the High Court here said that the principle of dura lex sed lex, the law is harsh, but it is the law, was upheld, and hardship to Go Air and its employees cannot override the legal obligations. So in this case, the aircraft licenses, they were cancelled. Okay? So it was deregistered. Cancellation of license. I hope this case law is also clear. Yes, next. Sundaresh Bhatt versus IBBI. Here, this Sundaresh Bhatt was the liquidator. As a liquidator also, this regulation 35 of liquidation regulation says that you have to appoint two valuers for assessing the realizable value in case of liquidation. The point is that a valuer is an independent expert, but this appointment was done in the firm's name and not in the name of the approved valuer. And he mandated a non-refundable deposit for submission of expression of interest. Later on, the provisions were changed and they said that you cannot ask for any non-refundable deposit. But the High Court found these lapses not very serious. Another lapse was that he appointed a professional, this BDO restructuring. So BRAL was appointed as a consultant, as a professional. And the remuneration of this BRAL was higher than the liquidator. He was a partner in BDO. So it was deemed as a conflict of interest and a deliberate attempt to circumvent Regulation 4 of the liquidation regulations, which caps a liquidator's remuneration. The fees paid to BRAL exceeded what Sundaresh Bhatt was entitled to, and the terms were vague and unjustified. So the point here is, if you are a liquidator and you appoint a professional under you whose fees is higher than what you are getting, and you are a partner in the same company, he was a partner of BDO, and the fees paid to BRAL, they exceeded what Bhatt was entitled. So it was deemed as direct conflict of interest and deliberate attempt to circumvent Regulation number 4. So he was held guilty on this account, and his license was suspended for 24 months. But since suspension of AFA, he had already undergone 20 months. 20 months have already elapsed since AFA was suspended. So the suspension of ASA was restricted to 20 months, which is already elapsed by the High Court. This was the case. Okay? Next case. Next case is Rohit J. Vora versus IBBI. Now, what is this case? If we read section 220 subsection 1. Let us read section 220 subsection 1. Pradeep ji, I will request you to go through this section 220 subsection 1 and what it says.
Section 220.
Section 220 subsection 1, if we say, so it says the board shall constitute a disciplinary committee. Yes, please.
The board shall constitute a disciplinary committee to consider the report of the investigating authority submitted under section 6 of subsection 6 of 218, section 218.
Yes, provided
that members of disciplinary committee shall consist of full-time members of the board only.
Yes. So the point here is they have written the word members. So this proviso was highlighted that since you are referring to members, so this disciplinary committee cannot become a cannot be a one-member committee. This was the point. Because they say you are referring to members. So members of the disciplinary committee appearing the proviso to section 220 subsection 1 as we have read just now, it makes a reference to more than one member. So the disciplinary committee cannot consist of a single member. But the High Court said that singular includes plural and vice versa. So they said even if the word members is written, so still the committee may be a single member committee also. There is no such bar on this. This was the point. Next case is IBBI versus State Bank of India. If we read Regulation 36A, so what Regulation 36A says? Let us go to this Regulation number 36A of CIRP regulations. So Regulation 36A, if we see, it is a detailed regulation. 36A, it talks of invitation for expression of interest. Now the point here is that I normally equate it with the process which normal people follow when they are looking for a match for their wards. Okay. Suppose you are looking for a match for your daughter, so then what you will do? You will give an ad in the paper. You will not disclose the complete details. You will say that, okay, you first give us the details of the boy and then we'll give you further details. So this process, it is described in detail in Regulation number 36A as to how to proceed with the invitation for expression of interest. Now, this NCLT, when this matter went to NCLT, so NCLT said that Regulation 36A is ultra vires. Okay? Of section 240 subsection 1 on the ground that it is contrary to the speedy disposal of the resolution process. Because section 240 subsection 1, if we say, what section 240 says? If we go to section 240 subsection 1, so then it says the board may by notification make regulations consistent with this code and the rules made thereunder to carry out the provisions of this code. Now they say, you are saying on the one side that it is to be a time bound, and then here you are detailing the process. So they said this Regulation 36A, which outlines the detailed procedure as to how the resolution applications will be invited, is ultra vires because it is contrary to the concept of speedy disposal of the regulation process. Section 240 subsection 1, if we say, it says the board may by notification make regulations consistent with the code. So they said if you are making something consistent with the code, that means it must follow the intention of the preamble, the intention of the legislature, and the intention of the legislature is that there should be a speedy disposal. So why you are making regulations like this? You know, that you first you give brief particulars and then you get detailed invitation and all those things. You know? So they said this NCLT said that this regulation 36A is ultra vires because it is contrary to the concept of speedy disposal. Okay. Despite there being no specific challenge to the said regulations. So, but High Court held otherwise. High Court said that NCLT doesn't have this power. High Court said that NCLT doesn't have jurisdiction to rule on the validity or legality of regulations framed under the IBC. Its powers under section 60 subsection 5 are limited to cases arising out of or in relation to. So we have to read section 60 subsection 5 also with this. So if we go to section 60 subsection 5, what it says? Section 60 subsection 5 says,
The NCLT shall
yes,
have jurisdiction to entertain or dispose of.
yes. So it says arising out of or in relation to. Basically, they said this thing.
C, sir, clause C.
Yes. any question of priorities or any question of law or facts arising out of or in relation to. So High Court said that this arising out of or in relation to is important, because what you are discussing, NCLT here is discussing regulation 36A. So they said it is not out of insolvency resolution or liquidation. NCLT has got certain powers, but they cannot comment upon the legality or validity of any regulations framed by the IBPA. So its powers are limited to cases arising out of or in relation to resolution or liquidation, not the broader legislative or regulatory domain. Okay? So this was the point. Next case is of Jenny Thankachan versus Union of India. So this case was a case of personal guarantor to CD. So the point here is that we discussed yesterday also that in case of personal guarantors, there is a concept of interim moratorium. So the interim moratorium triggers as soon as the application is filed, and when this application is admitted, then moratorium commences. So this is a case of personal guarantor to corporate debtor, but High Court said for an interim moratorium under section 96 of the IBC to come into effect, the application must be complete and free from defects. In this case, the petitioner's application had only been assigned a diary number and had not been formally registered by the NCLT due to procedural deficiencies. So the point is, if an application is assigned a diary number and it has not been formally registered, whether interim moratorium will commence or not, this is the question. So High Court said the interim moratorium has not been triggered in this case. So the gist is that interim moratorium shall trigger on filing of complete application free from defects. If the application is kept pending due to some procedural deficiencies, then in the meantime, that interim moratorium shall not be triggered. This is the point. Okay. So now we can see the NCLT cases. This is a case of Varsana Ispat. There are basically three legislations on this PMLA. And we can remember them as VRS. V is Varsana Ispat, R is Rajiv Chakravarti, and S is Shiv Charan. Okay. Now in Varsana Ispat, what was held by NCLT? So NCLT said that section 14 does not override PMLA. So they said this, they relate to the proceeds of crime. So they said that section 14 does not override the PMLA in case of money laundering, and assets seized by the ED under PMLA even during the moratorium period of IBC cannot be released under section 14. PMLA deals with the proceeds of crime and money laundering, making section 14 of the IBC inapplicable to such cases. अच्छा, वो लाइट एक तो बंद कर दो मेरे ख्याल, उससे हो जाएगा।